Hello friends, welcome back to our channel Legal Nexus. Every law has a story. It comes from somewhere. But where exactly do our laws originate? The answer lies in the source of law. These are the root gives legal rules their authority, whether it is an act passed in parliament, a judgment by the court, age old custom, or even moral and religious principles. In this video, we'll explore the main source of law and understand how they shape the legal system we live under. Sources of law. The law of the state or any organized organization of men is constituted of the rules that the courts, which are the body's judicial organs, set forth for the determination of legal right and or obligation. According to John Chipman Gray, a former professor at the Harvard Law School, Gray separated law from the sources of law, despite criticism that his definition was too restrictive. He contents, case law, and other legal sources have helped to shape the development of the law and provide the basis for its legality. Law, in its simplest form, refers to the regulation or standard of behavior and sources related to the sources of its information. The term law is used to denote a body of rules to guide human action, law regulate and control the external human conduct, backed by the sovereign political authority. The term law has been defined by different authorities in different way. Some of the definition are given below. Wilson, law is that portion of the established thought and habit which has gained district and formal recognition in the shape of uniform rules backed by the authority and power of government. T.E. Holland, law is a general rule of external human action enforced by a sovereign political authority. Legislation, one of the major sources of law. Legislation. The term legislation is derived from two Latin words, legis and latum. The word legis means law and the word latum means to make. Etymologically, legislation means to making or setting of laws. The term legislation can be used in two senses. In its widest sense, it includes all type of law making including declaration of law by the judiciary. In its narrow sense, the term legislation is used to denote law making by the legislature. According to Salmon, legislation is the declaration of legal rules by a competent authority. According to Gray, legislation is the formal utterance of legislative organs of the society. Legislation is the promulgation of legal rules by an authority duly empowered in that behalf. Legislation is the enunciation of legal rules by a competent authority in a state established for the purpose of lawmaking. The laws enacted by the legislation of the state is known as enacted law, statute, act, code, or written law. Legislation is an important source of law. Legislative power of the parliament and state legislature. In a country, the authority to make law may be vested in a person or a few or body of persons or different body of persons. In unitary states, normally there will be only one authority to enact laws. In England, the parliament is authorized to enact laws. In federal states such as USA and India, there are different authorities who are empowered to enact laws. In a federal state, there will be a written constitution clearly demarcating the law-making power of each body or authority. In India, the seventh schedule to the constitution classify the subject for the law-making into three. List 1 of the seventh schedule state union list contains subject on which the parliament can enact law. The second list of the seventh schedule state list contains the subject on which the state legislature can enact law. List 3 contain concurrent list. Concurrent list means subject on which both the parliament and state legislature can enact laws. Doctrine of pith and substance play a crucial role in understanding the legislative power of union and state legislature under the Indian Constitution. Sometimes the state legislature may enact law on a subject included in Union list of Parliament may enact law on a subject in the state list if state legislature enact law on a subject in the Union list. The Supreme Court or High Court can declare that law as ultra vires the Constitution. If the Parliament enact law in the subject of state list, then also the court can declare that law as ultra vires the Constitution. In order to declare a law as ultra vires, the court will apply the doctrine of pith and substance. By applying this doctrine, the court will examine the enactment to determine whether the law is in pith and substance within the competence of the legislation. If the legislation has substantially trespassed or trespassed into the competency of another's legislative power, the law will be declared as ultra vires. Colorable legislation. This doctrine is also important in legislation. If the legislature, which has only limited power, enacts a law prima facie seems to be within their powers and indirectly dealing with a matter which another is only competent to enact law, such a law legislation is called colorable legislation. Colorable legislation is a law indirectly dealing with a matter which the legislature is not competent to deal directly. Colorable legislation is a legislation which really transgressed the limits of legislative power, but the transgression will be indirect or covert. Such a law will be declared void, being ultra vires. Legislation in violation of fundamental rights. In India, Parliament and state legislature are competent to enact laws. The President and governors can promulgate ordinance. The law-making power of these body is subject to the restriction that they cannot enact laws in violation of fundamental rights enumerated in Part 3 of the Constitution of India. Part 3 of the Constitution provide for the right to equality, right to freedom, right against exploitation, right to freedom of religion, culture and educational right to constitutional remedies. If the Parliament or state legislation enact a law in violation of any of the fundamental rights enumerated in Part 3 of the Constitution of India, the Supreme Court or High Court can declare such law as unconstitutional. Doctrine of Eclipse. By virtue of Article 13 of the Constitution, if a pre-constitutional law or a post-constitutional law is found to be violative of fundamental rights, the Supreme Court and High Court can declare such a law as unconstitutional. When such a declaration is made by the court, the law will not become ab initio, void. The only effect of such a declaration is that the law will become unenforceable. It will remain in a moribund or dormant condition. It is not dead but only overshadowed by the fundamental rights. It is eclipsed by the fundamental rights. Such a law will not be wiped out entirely from the statute book. The said law can be implemented against any person who has no fundamental rights. The law which is declared unconstitutional can be revived by an amendment to the Constitution or Act so as to remove the eclipse or shadow of fundamental right. Once the amendment is effected for removing the unconstitutionality, the law will become enforceable from the date of amendment. Enforcement of fundamental rights. The writs. Article 32 of the Constitution empower the Supreme Court to issue writs in nature of habeas corpus, certiorari, prohibition, mandamus, and quo warranto for the enforcement of fundamental rights. Article 226 of the Constitution empower the High Court to issue writs for the enforcement of fundamental rights or for any other purpose. Different writs. The Supreme Court and High Court can issue the following writs for the enforcement of fundamental rights. Habeas corpus. The writ habeas corpus literally means produce the body. The writ of habeas corpus is issued when a person is detained by another illegally or without any lawful justification. It is issued to release the detained, the person from illegal detention. The writ of habeas corpus issued in the form of an order directing the person who has detained another to bring that person before the court and inform the court by what authority he has detained that person. If the cause showed for detention is not justifiable according to law, the court will order immediate release of the person under detention. If the cause showed are justifiable, the court will reject the application. The writ of mandamus is an order of the court commanding a person or a public authority to do or to refrain from doing something in nature of public duty or statutory duty. If a public authority who has to perform a public duty fails to do his duty and which has violated a person's fundamental right, the court will issue the writ of mandamus to that authority and command the authority to perform his function. Certiorari. A writ of certiorari is issued by the Supreme Court or High Court to quash or nullify an order made without jurisdiction or in violation of the rules of natural justice by an inferior court or body exercising judicial or quasi-judicial functions. Prohibition. A writ of prohibition is issued to prevent an inferior court or tribunal from exceeding its jurisdiction or acting contrary to the rules of natural justice. It is issued by the Supreme Court or High Court to keep the inferior court within the limits of their jurisdiction. It is issued to judicial and quasi-judicial bodies for preventing them from exercising jurisdiction which is not vested in them or to prevent them from abusing the jurisdiction. Quo warranto. The word quo warranto means what is your authority. This writ is issued to person who hold a public office to show the court under what authority he holds the office. When an application for a writ of quo warranto challenging the authority of a person holding a public office is filed, the court will issue a show cause notice to the person holding the public office. The holder of the office can show the authority under which he holds the office. If the inquiry leads to the finding the holder of office has valid authority to hold it, the court may pass an order preventing the holder from continuing in office and may also declare the office vacant. The object of the writ of quo warranto is to prevent a person from holding an office which he is not legally entitled to hold. Let's get into supreme and subordinate legislation. According to Salmon, legislation is either supreme or subordinate. A supreme legislation is that which proceeds from the sovereign power in the state. A supreme legislation cannot be repealed, amended, modified, annulled, or controlled by any other legislative authority. A law enacted by the Parliament of India is a supreme legislation. A subordinate legislation is that which proceed from any authority other than the state. A subordinate legislation is dependent for its continuing existence and validity on some superior authority. The subordinate legislation is made under the powers delegated by the supreme authority. Subordinate legislation may be classified into the following classes. Autonomous legislation. When the supreme authority confers powers upon an autonomous body to legislate on matter entrusted to them, the law made by the autonomous body is called autonomous law. The Kerala University is an autonomous body. It is created by the Kerala University Act. The statute confers power on the Senate to make rules. The rules and regulation made by the Senate is known as autonomous law. Colonial law. The countries which are not independent and are under the control of some other state have no supreme power to make laws. When such a colonial state make laws by exercising the power conferred to it by the controlling state, it is as colonial law. The laws made by the colonies are subject to the supreme legislation of the state under whose control they are. Executive legislation. The legislature may delegate power to make rules to the executive branches of the government. The act by which the power is delegated to the government is known as Parent Act. When the executive branch make rules by exercising the powers conferred to them, It is known as delegated legislation. Judicial legislation. The legislature may confer power to the court to make rules for procedure and practice in the court. When the judiciary make rules in exercise of its power for the practice and procedures, it is known as judicial legislation. The Supreme Court rules of practice and the Kerala High Court rules of practice are example of judicial legislation. Municipal legislation. The legislature may confer power to the local bodies such as municipalities and panchayats to make bylaws. When the local bodies make bylaws, they are known as municipal legislation. Thank you for watching this video. If you find this video helpful, please like, share and subscribe for more legal insights. See you on next part of this video.